He is a terrific legal mind to help sort out so much of what's going on with the law. The former federal prosecutor, now working the defense side of the table. How about it for the great David Katz, everybody? Hi, David.
Great to be with you. I'm getting over
David,
a cold. I'm getting over a cold, so bear with me. I'm doing the best I can.
Oh, okay. We'll crank David up. But I'll tell you, not that it's important, but you look great. So I don't know how you'll sound, but you look great. All right. So, David, let's start with the Trump stuff, and then I want to kind of get into women's reproductive rights and the fact that they've just rolled back that 1800s law that they tried to put in effect in Arizona. In the Trump trial, in the trial in Manhattan, what are the things that you're watching, and what might you say about the gag order punishment and the likely violations of that gag order going forward?
Well, this is an unusual cat and mouse game, which a normal criminal defendant wouldn't have with the judge. I mean, this is really unique because Trump wants to run right up to the line where he actually gets thrown into jail. Throwing him into jail could come in about three forms. The one everyone's thinking of is that he'd be trotted out to Rikers Island right now. The judge is not interested in doing that because it would delay the trial. In addition to that, it would also give a huge amount of publicity of the sort that Trump wants to milk for his base, and maybe even for some swing voters who think, well, this is, how did we get to this? Maybe the deep state is after this guy. So the other way that it could happen, Mark, is that he holds him in contempt and says, my penalty is going to be 30 days in jail, but I'll impose that to start at the end of the trial. That has a couple of advantages. It doesn't delay the trial and thereby play into Trump's hands by giving him the delay that he always wants. It doesn't, put the focus on him in a way which is lurid and tawdry, but yet which seems to be playing to his favor, at least so far in the polls. And the other one would be that there might be like a lockup. It would be like a timeout for a kid. And you'd put him in the lockup in the courtroom, which there is one, where they hold prisoners right before they bring them into the courtroom. And you would put him in that lockup. You would, to use the great old expression from Washington, D.C., you would step him back, and he'd have like a 3-hour cooling off period. The Secret Service would go in that room with him. It would be just a couple of Secret Service agents and him. And then you'd let him out 2 or 3 hours later, hopefully with an apology. I'm sorry, Your Honor, I wouldn't do it again. But, the $9,000 is, of course, ridiculous. However, the law in New York is it either has to be an admonishment. Well, he's been admonished till the cows come home, $1,000 fine per violation, or 30 days in custody. And as I say, the judge is very loath to do that. He said, if there's a contempt right in front of me, in other words, if you tell the judge F you to his face, yes, that will get him locked up right away. But Trump's smart enough, he's not going to do that. And his latest ploy today is he's taking advantage of the fact that, Michael Cohen is going on TikTok. He's asking for money. He's supposedly monetizing his own criticism of Trump. Can't Trump, in fairness, answer back at least against that witness? And Stormy Daniels has also tried to, from Trump's point of view, exploit the fact that, she's at the center stage in this big trial. Doesn't he have a right to blast back, at her? And now what's happening is that he's having the House Judiciary Committee and the House blast back for him at Michael Cohen and people like that. He's having surrogates, and it's pretty obvious. You can't put his actual fingerprints on it. But as soon as the gag order goes into effect, Mark, right, now these criticisms of Cohen and some of the others that he wants to attack a prosecutor named Matthew Colangelo. Matthew Colangelo cannot be attacked under the gag order because he's not the district attorney and he's not the judge. He's one of the assistants in the office. And the idea is that those people would have their family at risk, and they don't have the kind of, protective duty that someone like District Attorney Bragg has. But Colangelo is an interesting person, and now that he can't blast him, Jim Jordan in the House is blasting him, subpoenaing records from the Department of Justice about him. He's actually a very distinguished lawyer who's worked on a lot of Trump cases. He worked on the civil case that Letitia James has against Trump, which could have been part of this whole big criminal case, along with the Michael Cohen hush money election interference allegations. Then, though, when Biden got elected, he went to the Justice Department. As I say, he's a very distinguished lawyer. There's no reason why he shouldn't have been hired. But he was the number 3 person acting in the Justice Department. Then, once a number 3 person was actually approved by the Senate, he stayed on as the top aide to the number 3 person in the Justice Department. And lo and behold, from Trump's point of view, lo and behold, because of Biden's control of this whole manipulation and machinations, he gets hired by the district attorney's office. Now, he is a logical hire because he knows an awful lot about Trump's situation, and Bragg wants to beef up that team. But, it plays into the narrative. And even at the time that he was picked, about, 8 or 9 months ago, the New York Times said in the article about Colangelo being picked, this is going to be fodder for Trump. But, everything is fodder for Trump. At some point, they need to prosecute these cases and move forward, realizing that everything's going to be fodder for Trump.
I love that you said that, because I think it's such a tired refrain, the idea, well, somehow if you do this to him or you prosecute, it's only going to make him stronger. He's only going to use that. I mean, if somebody deserves to be prosecuted, they ought to be prosecuted. If somebody deserves to get a gag order, they ought to get it. I mean, but I had a question for you, though, about the discretion the judge has in relation to the gag order, and then we'll move on from the gag order. You really broke it down so beautifully. You had mentioned the 30 days, et cetera. You mentioned Rikers, and you mentioned the... is there a discretion the judge has in all of that, David, or does it have to be 30 days, or could it be whatever the judge wants?
It could be whatever the judge wants. It can't be over 30 days per violation, but there's enough violations. If you start stacking it consecutively, it's very bad news for Trump. And, it's the old, it's that game that you play, right? Where, how far are you going to go toward the person? You're going to hit their hand. You're not going to hit their hand. It's that game that they're playing because Trump really doesn't want to go to jail. Yes, he liked that one mugshot photo. He could kind of use it. But jail, even for a day, is not something that Trump wants to do. You look at how uncomfortable he is in the courtroom, and the reporting on him being in jail, him losing total control of the situation. He's not going to be with some, thug who's going to beat him up. But still, there's something very unpredictable about it. I've had clients who faced that situation. I had 2 sisters, and one sister said, no matter what, I'm going to go to jail for my sister. When they lock me up for contempt for not telling on my sister, I'm going to woman up. I'm going to be tough enough for it. And I said to her, make sure that's really what you're going to do, because you're going to spend money on attorney's fees for me. And if you're just going to wilt, or wimp out after 5 or 6 days, tell me that now. Let's not go down that road. Anyway, she wimped out after 5 or 6 days, and she might have saved herself the whole 5 or 6 days in jail, because it was such a disorienting experience for a normal person. And Trump's been through, some people think the fact that he hasn't been in jail is truly a miracle, how close he's come. But I don't think he's ever actually been. So I don't think he wants to actually go, but he's going to push this as far as he can. That's what he does.
Well, the context that you put it in, also in relation to what he's going through now in the courthouse, is really a great reminder of what he's been robbed of so far. And it's not much. He's just been robbed of his freedom. In other words, he has to be there in the courthouse during that time. He has to stay quiet. He has to listen to some of these gory details about what went down and how he tried to hush all of this information in a way that would help him politically. So he has to sit there and suffer through that. But you're so right. The notion of upping that ante and actually putting him in a jail situation, I mean, it seems as though it would be, apart from that one publicity shot that you say, and apart from whipping up his base, an insanely tough spot for Donald Trump. So I want to, unless you have anything else on the Trump trial, maybe I wanted to move on to some of these reproductive issues that exist in legislation in Florida, for example, and also in Arizona.
I hope, Mark, I hope we can also get to the demonstrations, the encampments, and all that, because there is some law on that, and I think it would be illuminating if we touched on that. But let's do that after your next topic. Okay?
Great. I love that that's on the docket, because I had some strong feelings about it earlier, and I'd like to know whether they're underpinned by any kind of real legal thinking. So sometimes I emote and talk first without thinking about the law. So in Florida, there is a particularly grotesque law going down when it comes to women's reproductive rights and right over their own body. It's a 6-week abortion ban there. And of course, we know about what happened in Arizona, and we can get to that as well because they have now reversed, at least on the legislative level, that total abortion ban that existed in that state.
Mark, can I touch on that for 1 second?
Please, yeah.
Because the Arizona situation has not been very well reported. They managed to get a couple of Republicans in the Arizona House and a couple of them in the Arizona Senate. And for all I know, that's a real profile in courage. For all I know, they're going to be primaried. They're going to lose their career. They absolutely did the right thing, in my opinion, for women's rights and for all of our rights by voting the way that they voted. But apparently they didn't have the votes to actually make that law go into effect right away. And so it's going to go into effect once it's signed by the governor and supersede the 1864 law in due course. What due course means is that 90 days after the end of the legislative session. And so the decision is going to go into effect in a few weeks. And yet this new law is not going to go into effect for maybe 4 or 5 months. So during those 3 months, unless there's another profile in courage by a bunch of Republican House members and Senate members, and they may think that, the main fury of it all is behind us. There's not going to be the intense pressure on them to do something about this 3 or 4 months. But imagine, what are the doctors and nurses supposed to do during that interim? How is the system going to keep functioning once you smash it for 3 or 4 months? How hard it is to reinstate it. And then, of course, the huge problem, not just for the system, but for the women who need an abortion. Some of them medically, some for all kinds of reasons. Remember, the old 1864 law that's going to go into effect for several months has no exception for except for the life of the mother. And so we've had the grotesque situation so far in some of these states where an organ can fail. That's what we had in the U.S. Supreme Court decision from Idaho, where Justice Sotomayor said, let me get this straight, attorney for Idaho. Under your state's law, a woman's organ is going to fail unless she has an abortion. And the advocate for Idaho said, well, that's not the life of the mother. That's the failure of an organ. And they actually would have to wait in states like Idaho and Arizona during this interregnum, during this interval of 3 or 4 months that's about to occur, even though the situation has supposedly been completely cured in Arizona. It sure hasn't been cured for those 3 or 4 months. So Idaho was in the situation at the time of the Supreme Court argument, was just a week or 2 ago, that Idaho is airlifting a woman a day because they need emergency procedures. And under Idaho law, they can't give it to her until her life is at stake. So at least mercifully, the doctors there have been able, without getting prosecuted, at least so far, to airlift these women to other states so they can have the emergency procedure that they need, but they can't get over these draconian laws like the ones in Idaho and Arizona. I just had to emote on that.
No, I like that. And in fact, the instance to which you've referred, I believe maybe the back and forth with Sotomayor, I had read, and pardon me if my memory isn't clear on this, but it was a case in which the woman's life, or there was at least another case mentioned in which a woman's life they couldn't establish that it actually was at risk. It might have been at risk, but in other words, no doctors were ready to say, well, it really risks the life of the mother. And so they end up in the situation you're talking about, which is the mother's sent home. She ends up passing out, bleeding out is what happened. And then they did save her life, and they performed the abortion, and that saved her life. But the hospital and doctors originally had to turn her away under the law.
Well, you can't expect these doctors and nurses and other health professionals. I mean, they didn't sign on for this to maybe go to prison, to get hit with huge fines, and they just didn't sign on for this. And so then they call their attorneys and they ask the attorneys, well, what's the law here in Idaho? And the law in Idaho is they probably can't perform the procedure because bad health of the mother is not the criterion. Death of the mother. Imminent death of the mother. And, the medical charts show what they show. If the woman is in grave health, but not in imminent fear of death, who wants to be the nurse or doctor who performs that procedure and gets prosecuted?
The situation in Florida, might it be, I guess, is there no legal road to challenge it the same way? Or what are the options for women in Florida?
Well, Florida is a huge problem because of geography. If you're a woman in the Southeast, Georgia, South Carolina, what's the other state over there? Alabama, You could go to Florida in the old days, not driving that far, and you could get the procedure. If Florida's out, now you have to drive to, I think it's Virginia. So if you're a woman in Florida, never mind if you're a woman in Georgia or Alabama, you have to drive all the way to Virginia. How do you get time off work? How do you have the money? This is so awful. Now remember that at least for the moment, a woman can take the medical abortion pill, Mark, and so they can get that. A right-wing anti-choice judge tried to put a nationwide injunction so you couldn't get that pill, but that's not in effect. The U.S. Supreme Court did not put that into effect. A woman can still get that pill. If somehow that case disastrously goes the wrong way, even women in blue states couldn't get it. But for right now, women in blue and red states, which include Florida, could get that, and most of the abortions are done that way. But in terms of how they're going to actually attack the Florida law, I mean, they're going to take it up to the courts and attack it under whatever procedures they have, remembering that, Roe v. Wade's not good law anymore. And beyond that, I don't know exactly what the details of the litigation attack on it would be.
And now to the campuses. I'll just ask you what these campuses are, and these institutions are different because some of them are private institutions and some of them are public institutions. And I'm imagining that you're going to talk to us about the fact that the law applies differently, perhaps in both those cases and beyond. First you, and then I'll have some follow-ups.
Well, the misunderstanding in the general public of the First Amendment and free speech and what they mean is really mind-boggling. Not that there are limits on free speech. There's no absolute free speech, but free speech goes back to the First Amendment, and the First Amendment says Congress shall make no law that prohibits free speech. And then it's been applied to the states, so a state may make no law that prohibits free speech. A private institution, like a private college or university, is not the government. It's not the state. And that gives a lot more leeway to how they deal with demonstrations, how they deal with encampments, the sit-ins, all those kinds of things at private universities. Now, public universities like UCLA or Berkeley, where I went to, they are, they're bound by the First Amendment. But once you get into the First Amendment situation, there's reasonable time, place, and manner. And this issue came up in a major Supreme Court case, which was decided 7-2, Mark. So under the law, it's fairly clear. Under policies, under getting along with the students, under getting along with the faculties, all those things, I'm sure it's very difficult being a campus administrator with all of the different things that are pulling at you. But the idea that the law made me do it, the law made me allow encampments on the campus, even though they were huge and they were loud and they were disruptive and they went on for weeks. The law did not make them do that. The 7-2 decision actually is, the idea is that some speech does go over into conduct. It's symbolic, and there are some symbolic things that you can do. Speech is more than just speaking out of your mouth. Maybe it's burning your draft card as a way to protest the draft during the Vietnam War. Maybe it's being homeless for a night as a way to protest that there's not better treatment of the homeless. Guess what? That's the U.S. Supreme Court case. That's the case from decades ago where the Supreme Court decided 7-2 that people who wanted to sleep overnight on the mall in Washington, D.C. could not do so. They could not get a permit to do so. And the idea that it was symbolic speech to sleep overnight, to focus issue on the homelessness, that was not accepted by the U.S. Supreme Court, and not 5-4 like those maddening cases that we see all the time. It was 7-2. There were two dissenters, but it was Democrats and Republicans in the 7 that decided it. It's never been overruled. And so the reality is that you cannot have an encampment for a long time and say that it's speech. It's conduct. It's not reasonable time, place, and manner. You can get a permit. You can say whatever you want to within certain limits. We can talk about hate speech if you want to. But you can say what you want to within certain limits that are not hate speech, that are not immediate incitement to violence against someone else. There's a case where some white people, I don't know if they were white students, but they want to intimidate black students at a university or college. And they there was I guess it was in Mississippi, there was a statue of Meredith, who I think was the first person to integrate the University of Mississippi or Alabama. There's a statue of him, of a black man, a statue of a black man. They put a noose around his neck and screamed all kinds of intimidating things at black people. No, that's not free speech. But within the limits of free speech, you can get a permit, reasonable time, place, and manner. You can't interrupt finals. You can't stay there all night. And my understanding of the law is that you cannot get a permit that allows you to stay overnight. When you're done with the demonstration, you have to leave. And if you look at the demonstrations in the late 60s, which I was proudly a member of, the mobilization against the war, efforts to have less discrimination in the country, the same kind of things that Martin Luther King Jr. was pursuing. Very proud of my participation, but there was a permit, and it was a reasonable time, place, and manner, and it was over. We went home, and we didn't disrupt other people or attack other people or yell at other people. We were sometimes yelled at because of our political views, or Mark, you remember this, because we had long hair.
I was just about to say, because you're long-haired hippies. That's why I got yelled at. Yeah. And with your Dayglow signs and your blacklight world, you were there at the epicenter of real civil unrest, but that you make such important distinctions. And I must tell you, earlier in the show, I said that I applaud the open discourse that you can find on college campuses, but this is out of control. I would never have had I been a college president, I would never have let there be overnight tents set up and essentially tent cities in the Quad and all the rest of it, and the blockage of classrooms and a takeover of administration building. That is, just zero tolerance for this stuff. And I think and we also reviewed earlier the fact that some universities, a handful of them, actually had a back and forth with protesters and constituencies on their campus that cared very much about this issue, and they made progress, and they actually made some concessions to them. But they didn't end up with the kind of situations that we're finding in so many of these other universities. But it's interesting to know that essentially the law allows these university presidents and allows these authorities to make arrests on campus.
Well, they have to make the arrests, of course, in the most appropriate manner possible. They can't engage in, you look back at the 1968 Democratic National Convention in Chicago. I was a little bit too young to have gone and protested there. But that was a police riot, so found by the Blue Ribbon panel that investigated it. And the cops did just want to beat on people. And so you can't have that. But, we're so much more sophisticated. The people who say, well, the Democratic Convention that's going back to Chicago this summer, maybe it'll be just like, Richard Daley's thugs and, what happened there. The whole world is watching. The law enforcement learned an awful lot from that. And these conventions now, like the one that's going to be in Chicago now, is not going to be a bunch of rogue, out of control police officers. It's going to be very professional. They train for this. They put money into this. They know what they're doing. There will be provocateurs. There always are. There are people who are, agent provocateurs. They want it and to be a disaster. And I would look to, people who are in favor of Trump, definitely, because they hope that they can get ahead by there being this perception that there's so much crime and disorder. And of course, we all know what happened in 1968. A lot of people think that the outside agitators and the excesses of some of the demonstrations, some of the riots on campus that were completely out of control in those days, elected Nixon.
And it is worth noting that in a couple of these situations, I think certainly at Columbia, cops were sent in and they didn't allow journalists in at all. And there still is, I think, badge cam, and there's still enough citizen journalism going on with iPhone and Android recordings, hopefully to, keep the cops honest that way. They're, look, it's an ugly situation, and I feel it never should have gotten to that point, but it's interesting to know what the law is on all of this. And now I want to double back for a moment to Trump, and then I'll let you go. My double back is about a prediction. First, I want clarification. All Trump needs, David Katz, is he needs one juror, right?
Well, you keep hearing that, Mark, and by now there's so much coverage, and a lot of times I'm part of it. There'll be four of us on a panel, and someone will say that, and I have to kind of bite my tongue because, is it really appropriate on the panel? And I don't want to be, I don't want to get into that thing where they put us both on the screen, and they're doing that, point, counterpoint, the famous thing from Saturday Night Live where the one guest says to the other guest, "You ignorant slut," and it becomes that kind of, to me, that's no way to put out the legal opinions or the news and stuff
So
like
is
that.
it not one juror that Trump
Well,
needs?
here's the point, okay? It would be a hung jury. It would be tried again. Yes, it would be a way not to be convicted, not to be found guilty before the election. It's hard to imagine that they could put on a retrial. And of course, the people's interest kind of tends to flag. But it's like the Harvey Weinstein. Harvey Weinstein is going to have a retrial in New York, and I imagine that the witnesses who are properly allowed to testify, they're going to show up again. There's no reason to think that they wouldn't show up again. Will it be traumatic to tell their story again? Yes. This trial, much less so. I mean, these are not, this Davidson, who's just been on, the Beverly Hills lawyer, and they try to, imply that he's an extortionist. He's not an extortionist. The man is performing, legal services, not what I chose to do with my career. I'm glad that I don't have that practice. But, they'll come and tell their story. Will Michael Cohen come and tell his story at a retrial? Yes. So the idea that they just need one. And the other thing, too, is that when they vote and they come back and they say it's 11-1, the judge doesn't say, "Oh, well, I guess it's just 11-1. They give them what's called an Allen charge. They tell them to keep deliberating. They tell them to, discuss. They give them all kinds of instructions on that. And if this is very controversial, especially as a criminal defense attorney, because you do have a right to a unanimous jury. But every now and then it does turn out that some juror, you can point to something where the juror is so biased or they've used outside influences so clearly that the judge may actually dismiss them and put the alternate in their place. Again, that's very dangerous. It's dangerous because the idea that it's got to be unanimous, and if the person has I mean, the person has reservations. Those reservations should be honored. It didn't come out 12-0. It came out 11-1. And
Well, certainly in this case, it would be really dangerous because you'd have the suggestion or the appearance that, you didn't get the verdict you want, so you swapped out the juror for a juror that you did want.
It would be very, very controversial. It sure would be. But if the person was, clued into Trump social all the time, and you could show that, the person said, "Look, I've seen on Trump's," they said in the jury deliberations, "I've seen on Trump social that Trump is not, the feds didn't charge it. So that's good enough for me. The feds didn't charge it. Now the state is charging what the feds could have charged. If the feds didn't charge this guy, they charged John Edwards," all the things that we talk about politically. If that was the person's whole mindset toward the case, and that was revealed to the judge, and the person said, "Yes, that's my mindset," I think that person would be removed from the jury. A substitute juror would be put in their place. And yes, if that person is then convicted, you have an appellate issue. But the idea that all he needs is a hung jury. The other thing that is maddening to me is that he was indicted by a grand jury of his peers. Everyone who argues that the person was indicted by a grand jury will indict a ham sandwich mark. And the reason is because there's no right, maybe there is in the New York courts, but there's no right in the federal court to have exculpatory evidence presented. The U.S. Supreme Court decided 5-4. This has always been outrage. I'm on this soapbox. I didn't agree with this as a prosecutor. I don't agree with this as a criminal defense attorney. There's two witnesses in the bank. One of them says the robber was 5'4". The other one says he was 6'4". The defendant that they want to indict is 5'4". They could call the witness who said the guy was 5'4" and not call the witness who said the guy was 6'4", and that is a properly returned indictment in the federal system. Now, of course, that's an example that we give to show the absurdity of not having. I know we would make all these issues with criminal defense attorneys. You didn't present this exculpatory evidence. That was really exculpatory. We'd fight about it. Every indictment would be suspect because we'd say they didn't present exculpatory evidence. I get that parade of horribles. But mine is a really bad horrible. And when you have a case like that, that indictment should be thrown out. The other thing is it's not an adversary system, so the defense doesn't get to put on anything. So all the people who argue that there's a safeguard of the grand jury nowadays in many states, including in New York, Trump did call one witness. If you remember the situation, the indictment got delayed for a week or two while Trump did call an exculpatory witness. So, of course, that's what we always say. The only people who have really fair trials are police officers. Fair criminal trials are police officers when they meticulously follow all the rules. And they probably did meticulously follow all the rules, but still the standard in the grand jury is probable cause. and not even beyond a reasonable doubt. So the fact that he was indicted doesn't mean much to me. But the fact that he has 12 jurors, Mark, I think they're really going to try to do their duty. I said at the beginning of the case that this was a very tough case. I said that back in March 2023 when you and I were talking about it being charged. I said all that may happen is that the DA is playing into Trump's hands. Why would the New York district attorney want to bolster Trump's political fortunes in 2024? I said that back in March 2023, and that may be what comes to pass. I think that this jury is going to really bend over backwards to be fair, and I think Judge Merchan, who's taken a lot of incoming, I think he's been very fair in his ruling so far.
But let me get clarity on that. You think net, if Trump is found, well, net, tell me, political win, but legal loss and political loss? What's Katz's field net on all of this, on the Trump trial in Manhattan?
Net, I think that the district attorney, especially after announcing that he would, if elected, prosecute Trump, I think he should have not prosecuted Trump. But we are where we are. I think there's a good chance that he'll be convicted only of the misdemeanor. The falsified business records. It has to be in furtherance other unlawful act, which is violating federal campaign laws or state campaign laws. I think that the key thing, although they're trying to set it up, Mark, to give all of this anticipatory corroboration for Michael Cohen and to get the jury ready for that, there's a point where Trump says, pay her cash. And Michael Cohen says on a tape recording that the jury's going to hear, he says, no, I got this all covered. From the time that Michael Cohen says, I've got it all covered, Trump is going to say he was an attorney. He was a smart attorney. I used him for a lot of things. He'd had a lot of success. He figured he had it all covered. He had it all covered. That somehow this was lawful. The guy wasn't going to get himself disbarred. He hadn't gotten himself disbarred in all the years he's been representing me. Why would I think he was going to get disbarred over this? Why would I think he was going to be violating federal or state campaign finance laws? The prosecutors are going to argue, well, Michael Cohen told that to him. He told him it was a felony. He told him, I'm going to take care of it, but not because it's legal. I'm going to figure out a way to dance around it. And that's where they're going to have a problem, I think, with proof beyond a reasonable doubt. That Trump is going, they're not able to show beyond a reasonable doubt, Mark, that Trump didn't just leave it in the hands of Cohen, figuring out that he knew a lot more of the legalities and the law. Remember, this was happening 2 weeks before the presidential election, which cuts two ways. One, that he desperately needed to silence her, and he didn't care if he broke the law to do it. But the other way is a woman's awfully busy, like Hillary and he were, running for president. How much time did he really have to parse this all out? And when you have different scenarios, remember, reasonable doubt means that if there's two different scenarios that make sense, not guilty. Wow. So I'm worried about the felony, but I think he will get unanimously found guilty of the misdemeanor. And he'll argue, wow, all that work and all that expense for what's basically a traffic ticket.
Right. And I'll remind everybody on the gag order stuff that David's made the point here before that Donald Trump is allowed to go off on the judge and go out on what a partisan judge he is. And, you've reviewed for us before that that's totally cool under the gag order. But as you've also said in our visit today, when he starts going after some of the others who are in the prosecutor's office, et cetera, that is a clean violation of the gag order. So we'll watch for that.
Let me say one last thing. And the jurors, that one's outrageous. And we saw that this one, now she was outed a little bit by the press, I think, who reported, and the judge wasn't careful enough to keep it only in chambers. So they knew that she worked at a particular hospital in New York. And she took herself off the next day. She said, I didn't sign on for this. But I think that he'll stay away from the jurors, Mark. And of course, that's absolutely essential, that there not be any commentary like that's untoward about the jurors that exposes in any way the jurors. And I think the judge is all over that right now to make sure that people in the courtroom, I don't know if they have to sign. I wasn't actually in the courtroom. I was in New York doing this, and it was awfully interesting seeing some of it, but I didn't actually get in the courtroom.
What I love about David Katz in New York and on New York media and Fox 5 and the Fox News Channel and these other places where you show up, I love that they also ask you to comment on Eyewitness News in New York, I think, had you on. They ask you to comment on cases that are big deals to New Yorkers, but that we've barely heard of in California. You know what I mean? Something that happened in the subway or in a cab or something. So I love that you're able to, review the specifics there, and immerse yourself in the law such that you're able to be an expert on things that, don't make national news. They're kind of important to New Yorkers, as well as obviously the Trump Manhattan trial, which is, larger than life. So always enjoy. Yeah, go ahead.
I'll be on Times of London early tomorrow morning. So if any of you have a flight over the pond, turn on your radio in the morning. Times of London.
Times of London, everyone.
Thank you so much.
Thank you so much. The great David Katz, everyone. Thank you, David. Thank you. Katzodamus. Yeah. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.